Question 841. A contract signed by a minor is A. Voidable, B. Void, C. Unenforceable, D. None of the above. Correct answer is A. Voidable. A void contract is one that was never legally enforceable from the beginning. It's as if it never existed. Contracts for illegal purposes are void, for example. A contract with a minor is generally not void from the start. An unenforceable contract is a valid contract that cannot be enforced in a court of law, often due to a legal technicality, like not being in writing when required by the statute of frauds. While a minor's contract might become unenforceable if the minor disaffirms it, voidable more accurately describes its initial status. A contract signed by a minor, someone under the age of legal majority, which is 18 in most states including California, is generally voidable. The contract is valid and enforceable unless and until the minor chooses to disaffirm or void it. The minor has the right to cancel the contract, typically within a reasonable time after reaching the age of majority. The other party to the contract, however, usually cannot void the contract due to the minor's minority. There are exceptions where a minor's contract might not be voidable, such as contracts for necessities, food, clothing, shelter, or if the minor misrepresents their age. However, the general rule remains that a contract with a minor is voidable at the minor's option. Question 842. When a real estate agent pays a portion of his or her commission to the buyer, the agent is required to A. Inform the escrow agent, B. Inform the seller, C. Be subject to prosecution by the district attorney, D. There is no requirement for the agent to do anything. Correct answer is B. Inform the seller. When a real estate agent pays a portion of their commission to the buyer, they are essentially reducing the seller's net proceeds from the sale. Therefore, it is crucial for the agent to inform the seller about this arrangement. This disclosure ensures transparency and allows the seller to make informed decisions about the sale. Failing to disclose this information could be considered a breach of fiduciary duty and may have legal consequences for the agent. Question 843. A. And provides the holder with the right to use another person's property without holding an estate. A. Easement, B. Variance, C. License, D. Reversionary interest. Correct answer is A. Easement. A variance is a deviation from zoning ordinances granted by a local government. It allows a property owner to do something on their own property that would otherwise be prohibited by zoning laws. It does not involve using another person's property. Reversionary interest is a future interest in real property where the property reverts to the original grantor, or their heirs, after a specific event, e.g., the termination of a life estate. This is an ownership interest that becomes possessory in the future, not merely a right to use another's property without holding an estate. A license is also a right to use another person's property without holding an estate. But it is typically a personal, revocable, and non-assignable privilege, not an actual interest in the land. Think of a ticket to a sporting event or permission to hunt on someone's land. While it technically fits the description, in real estate law, an easement is the more formal and enduring right that creates an interest in the land, though non-possessory. In general real estate questions about property rights, easement is the primary answer when discussing enduring rights to use another's land. An easement is a non-possessory right to use another person's land for a specific purpose. For example, a utility company might have an easement to run power lines across your property, or your neighbor might have an easement to cross your land to access a public road. The holder of the easement has a right to use the land, but they do not own the land or hold an estate in it. Therefore, an easement most accurately fits the description of providing a holder with the right to use another person's property without holding an estate. Question 844. Which is not a required element for the creation of an agency relationship? A. Payment of consideration, B. The subject of the agency is not illegal. C. Agreement by the parties. D. Competency of the principal. Correct answer is a payment of consideration. For the creation of a valid agency relationship, the following elements are generally required. Agreement by the parties. C. Both the principal and the agent must consent to the relationship. This consent can be express, written or oral, or implied by their actions. Legal purpose. B. The activities or subject matter of the agency must be legal. An agency created for an illegal purpose is void. Competency of the principal. D. The principal must have the legal capacity to enter into the agency agreement and to authorize the agent's actions. The agent also needs to be competent, but the question specifies principal. Payment of consideration, e.g., a commission or fee, is usually involved in a professional agency relationship. But it is not a legal prerequisite for the creation of the agency itself. An agency relationship can be formed even if the agent is acting gratuitously, without pay. Question 845. An advantage in owning an income-generating property is: A. Deduction of depreciation. B. Deduction of interest. C. Both A and B. D. Neither A nor B. Correct answer is C. Both A and B. Owning an income-generating property offers several tax advantages, including 1. Deduction of depreciation. Landlords can deduct a portion of the cost of the property, excluding land value, over time as depreciation. This reduces taxable income. 2. Deduction of interest. Interest paid on the mortgage used to purchase the property is often deductible. These deductions can significantly reduce the overall tax burden for property owners. However, it's important to consult with a tax professional to understand the specific rules and regulations that apply to your situation. Question 846. A contract breach will excuse the wronged party's duty to perform under the contract depending on whether or not the breach is: A. Minor or material. B. Compensatory or punitive. C. Practical or theoretical. D. Monetary or non-monetary. Correct answer is A. Minor or material. Compensatory or punitive refer to types of damages awarded for a breach, not the nature of the breach itself that would excuse performance. Practical or theoretical are not legal classifications terms of contract breaches. While a breach can involve money or not, this distinction doesn't determine whether the wronged party is excused from performance. A non-monetary breach can still be material, e.g., failing to deliver a unique item as promised. A material breach of contract is a significant violation of the contract's terms that substantially impairs the contract's purpose. When a material breach occurs, the non-breaching party is generally excused from performing their obligations under the contract and may seek damages. A minor breach is a less significant violation of the contract that does not substantially impair the contract's purpose. In most cases, a minor breach does not excuse the non-breaching party from performing their obligations, but they may be entitled to damages to compensate for the breach. Therefore, the severity of the breach, whether it's minor or material, determines whether the non-breaching party is excused from performing their obligations. Question 847. The market data approach in appraisal is based on the principle of: A. Substitution. B. Conformity. C. Socialization. D. Anticipation. Correct answer is A. Substitution. Principle of socialization is not a recognized principle of real estate appraisal. The principle of conformity states that maximum value is realized when a property is in harmony with its surroundings. Example: similar in style, size, and quality to other homes in the neighborhood. While important in appraisal, it's not the basis of comparing sales in the market data approach. The principle of anticipation states that value is created by the expectation of future benefits to be derived from the property. Example: future income, appreciation, amenities. This principle is more directly related to the income approach to appraisal, though it influences all value decisions. principle of substitution states that a prudent buyer will pay no more for a property than the cost of acquiring an equally desirable substitute property that is available without undue delay. In the market data approach, an appraiser looks at comparable properties that have recently sold. The assumption is that buyers in the market would substitute the subject property for a similar one if it offered comparable benefits at a lower or equivalent price. Therefore, the value of the subject property is substituted by the values of comparable sales. Question 848. Principal Pat asked broker Bill to advertise, show, and then sell Pat's home to buyer Ben. After the purchase agreement was signed, Pat tried to rescind it by saying that their listing agreement had expired. When Ben is able to prove that Pat was aware the term had expired and chose to let broker Bill show the house anyway, Pat will be compelled to abide by the purchase agreement due to the doctrine of A. Estoppel, B. Ratification, C. Unlawful detainer, D. Implication. Correct answer is A. Estoppel. Agency by estoppel applies when a principal, Pat, creates an appearance of agency, leading a third party, buyer Ben, to reasonably believe that an agent, broker Bill, has authority. Because Ben relied on Pat's actions, allowing Bill to continue showing the house despite the expired agreement, Pat is estopped, or prevented from denying that Bill had the authority to act as his agent, thus protecting Ben's interest. Pat's actions created the appearance of ongoing authority, and Ben relied on that appearance to his detriment, entering the purchase agreement. While Pat did effectively approve Bill's actions by letting him continue, the core of the compulsion here from Ben's perspective is that Pat led Ben to believe Bill still had authority. The emphasis of estoppel is on protecting the innocent third party who relied on the principal's conduct. In summary, estoppel focuses on the principal's conduct that misleads a third party into believing an agent has authority, thus binding the principal to protect that third party's reliance. Implication focuses on the agent's actions that create an agency relationship by conduct, protecting the principal, though it can also bind the principal. Ratification focuses on the principal's after-the-fact approval of an agent's unauthorized act. Since Ben can prove Pat knowingly allowed Bill to continue showing the house, Pat created an appearance of ongoing authority. This action led Ben to reasonably believe Bill was authorized to act as Pat's agent. Therefore, the doctrine of estoppel compels Pat to uphold the agreement to protect Ben's reliance on that apparent authority. Question 849. During the subprime loan era, arranging low payments in the beginning of the loan term enabled borrowers to purchase more expensive properties than they could actually afford. When the interest-only period of the loan ended and large amortized payments were required, the borrowers experienced A. Capitalization, B. PMI, C. Payment shock, D. Points payment overload. Correct answer is C. Payment shock. Capitalization is a financial accounting method used to allocate the cost of a long-term asset over its useful life. It's not directly related to the issue of payment shock. PMI, private mortgage insurance, is insurance that protects lenders from losses in the event of a borrower defaulting on their mortgage. While PMI can increase monthly payments, it's not the primary cause of payment shock in the scenario described. Points payment overload refers to a situation where a borrower pays too many upfront points to reduce their interest rate. While paying points can increase the upfront costs of a loan, it doesn't directly cause payment shock. Payment shock occurs when a borrower experiences a sudden and significant increase in their monthly mortgage payment. This often happens with adjustable-rate mortgages, ARMs, or interest-only loans, where the initial payments are low but then increase significantly later in the loan term. In the case of subprime loans with low initial payments, borrowers might have been able to qualify for larger loans than they could truly afford. When the interest-only period ended and the principal payments began, the monthly payments increased dramatically, leading to payment shock. This often resulted in borrowers struggling to make their payments, leading to defaults and foreclosures. Question 850. Most lending contracts have a right of rescission, which provides the borrower with the opportunity to cancel the loan without penalty if the right is exercised. A. Within 1 day after the loan agreement is made. B. Within 3 days after the loan agreement is made. C. Within a week after the loan agreement is recorded at the county recording office. D. There is no right of rescission available to cancel a loan. Correct answer is B. Within 3 days after the loan agreement is made. This right of rescission is mandated by the Truth in Lending Act, TILA. Specifically under Regulation Z, for certain types of consumer credit transactions secured by a borrower's principal dwelling. It applies to specific loans, most commonly refinances of a primary residence, home equity loans, and home equity lines of credit, HELOCs. Please note that this right does not apply to all types of loans. It generally does not apply to purchase money mortgages, loans used to buy a home, or to loans for secondary homes or investment properties. The 3 business days begin after the latest of 3 events: the signing of the loan agreement, delivery of the Truth in Lending disclosure, or delivery of the notice of the right to rescind. During this 3-day cooling off period, the borrower can cancel the loan for any reason without penalty.